Man, I'm so glad I've got my blaster all tuned up and modified to my specifications. It's a shame I can't carry it anymore, right? Today we're going to be talking about one of those classic FUD tales from the depths of ARFCOM. That if you modify your carry gun, you're going to go to jail forever. Or something.
While the host of Fuddbusters is a lawyer, he is not your lawyer. If you pay him, maybe, either way you slice it, the video that you are about to watch is not to be construed as legal advice.
We've heard it 100 times, be it at the gun shop, the gun range, the gun cafe, or even the internet gun club. Someone, generally overweight and unlikely to have ever fired their weapon in anger, will tell you, "Better not put that upgraded trigger on your carry piece, son, unless you want to give the prosecutor ammunition if you ever gotta use it." So I'll start with a bit of a spoiler here. This is FUD lore, mostly. Still, you'll hear it from such trustworthy sources as the Alien Gear Holsters blog and others. The prevailing contention here is that if you modify your carry gun, that the prosecutor, a term adherents to this lore errantly used when referring to both civil and criminal actions, will use that against you. But what do they mean by this? Well, usually nothing of import, because they're generally just repeating something they were told by an older, fatter version of themselves. You really shouldn't be mad at a parrot, you know. It's bad for your health. That aside, let's get to the meat and potatoes here. What kind of stuff could modifying your trusty heater possibly, potentially, maybe, perhaps have an effect on? Well, when we're talking about self-defense situations, there's two things that give people anxiety, and that's related to our discussion here. A criminal prosecution and a civil suit. The criminal risks are, of course, a wily prosecutor deciding to try to categorize a defensive gun use as a murder or manslaughter case. We'll dig into a couple areas this could be relevant to later on. The civil risks are things such as a wrongful death or other type of action in tort where the victim claims that the defensive gun user either acted negligently or intentionally, not in self-defense, and there are key differences here that we'll touch on as well. So let's dive into the criminal side. This seems to be what most people worry about. I mean, after all, you can't quite discharge a criminal conviction in bankruptcy. The obvious answer here is to, not shoot anyone under sketchy circumstances. That's a pretty safe play. Still, though, people are sometimes afraid of a politically motivated prosecutor or something trying to stick it to them. Naturally, the thing we do if we're faced with this type of situation is raise the legal defense of, well, self-defense. I'm going to warn you real quick, I'm going to have to say the word defense a lot. That's because self-defense is a legal defense, and we're talking about the possibility of holes being poked into your defense of self-defense. So the question the forum dwellers will fight it out over here is whether modifying your carry gun will wreck your legal defense. Self-defense is a legal defense based on principles of necessity and justification. In our common law system, there is a general policy that people who conduct themselves reasonably should not be punished. That's why necessity is itself a defense. If you absolutely had to do something, albeit illegal, to avoid a greater harm, our system is supposed to protect you. That said, in most states, self-defense has been codified and is now based on statute. Generally speaking, self-defense can be a defense to a charge of assault, battery, and the various flavors of homicide. There is a lot of state-to-state nuance here, but generally speaking, self-defense can be said to have four components: innocence, imminence, proportionality, and objectivity. Innocence means you didn't provoke the attack. Y'all knew that one, come on. Imminence means there was an immediate threat of serious injury or death. Proportionality means you used an appropriate amount of force, because it's generally frowned upon to respond to a dude swinging nunchucks with an ATGM. Finally, objectivity means your fear of imminent injury or death was objectively reasonable. Basically, someone who has a deeply held personal belief that anyone wearing a blue sweater is an assassin doesn't get to argue self-defense if they mow down everyone in blue. The Model Penal Code sums all this up, defining self-defense as justifiable when the actor believes the force is immediately necessary to protect himself against unlawful force by another person. Right, so now we've gone over self-defense. So how can your modified carry gun screw this up for you? Well, the arguments I hear most often are about what the prosecutor might try to use as evidence, and they're split up into cosmetic modifications and functional modifications. One thing people generally agree on is that it's probably a bad idea to put a Punisher skull on a firearm you might wind up using in self-defense. Could this be used as evidence that you didn't approach the situation with clean hands? Maybe. I think it's a pretty good suggestion for two reasons. Number one, you aren't a vigilante seeking revenge, and number two, it's cringe and nobody likes a guy with a Punisher skull on literally anything. The same thing goes for like racial epithets or whatever, or just anything else that's miserable and edgy that you might put on your gun. Where I disagree with the panic gun store countermen is when people claim that like a blue or red slide stop or trigger shoe will somehow help the prosecutor convince the jury that you were out looking for a fight. If you want my personal opinion, I feel like if your case was so thin that a blue trigger or pink frame convinced the jury that you were wilding out, you probably did something wrong. In short, on cosmetic mods, I think you can make your gun look silly if you want, but don't write slurs or put sheepdog nonsense on your gun, and that's obvious. If you needed me to tell you that, consider switching to pepper spray. Next, functional mods. How can these screw up a self-defense argument? I generally see two species of arguments here. One is the same as before, where mouth breathers parrot some inane idea that the very presence of a red dot or fancy trigger will convince any impaneled jury that you're a murderous psychopath. And also a more interesting argument. The more interesting one is the idea that lightening your trigger could enable an argument that you actually fired by mistake. This might make you scratch your head, but it's actually quite interesting. In most states, self-defense necessitates an intentional, rational action. If you claim you fired by accident, you usually can't carry out a self-defense defense. There are some people that argue this point aggressively, including a man I respect very much, who I will not name because I learned my lesson the last time someone thought that I called them out on my channel. Anyway, these people argue that the light trigger pull could handily destroy your self-defense claim, and that they have case law to back it up. One problem here is that most cases involving individuals in clear self-defense situations don't get far beyond the trial court and are thus not reported, so we don't have a lot of examples in the record. Another problem is that virtually all the cases people bring up related to this are civil lawsuits against police departments where the cop outright says that they fired a modified gun by accident, and thus the plaintiffs are going after the department for breaking procedures. This isn't quite the same situation as a man on the street fending off an attacker, in my opinion. The one exception is the oft-cited case of New York v. MacLeod, which people will cite as definitive authority that you are screwed if you have a lightened trigger. Of course, the case doesn't say that at all. They also leave out the fact that MacLeod involved a road rage incident where MacLeod had a heated exchange with another driver, then drove home, got a revolver, drove back to where the other driver was, and ran out to him shouting. The other driver then produces a nightstick, and MacLeod draws his revolver, cocking the hammer. MacLeod claimed that a passing car unsettled him, causing him to accidentally pull the trigger. So this is a case where an individual was fighting off a murder charge, and he was claiming that he only fired on accident, again trying to get away from murder. Still, people argue that this case proves that you modifying your carry gun will destroy a self-defense claim. I mean, I find it very hard to understand that, given the fact that weapon modifications weren't mentioned at all, and the self-defense wasn't even raised in the appeal. Whatever. If you ask me, I'm not concerned about modifying my carry gun to work better for me. I'm not afraid to put an optic on it, and I'm not afraid of tuning the trigger. I will say that modifying it to the point that it goes off just by looking at it is probably dumb. But, and I can hear them saying now, what you really got to be concerned about is them civil lawsuits. Sure, this is true. If you injure somebody and there's sketchy circumstances, there's a fair chance they'll come at you for damages. Our tort system is also rooted in the common law. It stands for the principle that if you act unreasonably, negligently, or recklessly, that you ought to pay for the damage you cause. Of course, self-defense is also a defense to civil causes of action. The same considerations we talked about there apply here. The main difference is that in a criminal case, the government has to prove everything beyond a reasonable doubt, whereas in a civil case, whoever can prove their side was more likely than not the truth will tend to prevail. The thing to understand here is that, just like in criminal court, plaintiffs in a wrongful death or battery action may bring up any number of absurd arguments and try to get them before the jury. Your defense lawyer may succeed in preventing some of these arguments or pieces of evidence from coming forward, but is a trigger job or pink frame the type of thing that you're really concerned about a jury seeing? If I were defending such a case and some simple modifications were the biggest cause of concern for me, I'd probably be feeling pretty darn good about my client's chances. The simple fact is that people can argue almost whatever they want. The question is whether that argument will make a bit of difference. I live with a simple philosophy. There are things that matter, and then there's everything else. If you ask me, worrying about legal ramifications of carry gun modifications is everything else. That's it for today. Let me just say I really appreciate you guys watching and subscribing. It makes a huge difference. If you want to support me more than that, I started up a Patreon and a Subscribe Star. I've added benefits like a patron-only podcast, a Discord, and there's surely more to come. This kind of support will help enable me to make more content more regularly, something I'd really love to be able to do. There's also a link to the new and improved Fuddbusters apparel, you can see here. We've also got stickers, and of course, the Magic ATF ball. This and some affiliate links to related reading are all in the description below. Thank you all so much for watching to the end and for your support. I'll see you next time, or if you become a patron or subscribe star, I'll see you on the Discord. Remember, the anti-side has been working long and hard, passing laws and trying to make more stuff. Anything more than minimum compliance is self-regulation. Y'all take care.